Hi, everybody. This is Advocate Lucinda, your empowerment lawyer. Somebody asked me a question about the statute of limitations and whether there is an exception to the time limit. And that's what we're going to talk about today, and equitable tolling. So let's get started. What is the statute of limitations? It is a time limit for filing charges against another party. It begins to run from the date of the injury, or 2, the date the injury was discovered, or 3, the date on which the injury would have been discovered with reasonable efforts. And I put emphasis on reasonable efforts because it gets into the next question asked by a pro se: is there an exception to the statute of limitations? One potential exception is equitable tolling. Equitable tolling stops the running of the statute of limitations time period. And we see this in a United States Supreme Court, where it held that equitable tolling requires a party to satisfy 2 distinct elements. 1, the party must have been diligent in the pursuit of his or her rights. And 2, some extraordinary circumstance exists beyond the party's control, preventing the party from timely filing. And I've given you a case here, which is a good read for understanding the concept of equitable tolling. Now, the party wants to look at its jurisdiction rules or laws. So we're going to look at 2 statutes that litigants often use when they file a claim for discrimination. Let's look at employment discrimination Title VII. That's the first statute. It has a 180 days limit, a 300 days limit, and a 90 days limit. So let's take a look. Under Title VII of the Civil Rights Act of 1964, an employee or applicant has 180 calendar days from the day the discrimination took place to file a charge with the Equal Employment Opportunity Commission, or EEOC. However, if a state or local agency enforces a law that prohibits employment discrimination on the same basis as the federal law, the deadline is extended to 300 calendar days. So once the complainant receives a notice of right to sue, he or she must file their lawsuit within 90 days. Now, this is critical because the deadline is set by law. If the complainant doesn't file in time, he or she may be prevented from going forward with their lawsuit. The second statute is equal rights under the law, 42 U.S.C. 1981. The statute of limitations is 4 years. So let's talk a little bit more about this statute. A lot of plaintiffs suing for racial discrimination are not aware of 42 U.S.C. 1981. In comparison to Title VII, for example, 42 U.S.C. 1981 applies only to intentional racial discrimination, whereas Title VII applies intentional discrimination based on race, color, national origin, sex, or religion. And a plaintiff filing a lawsuit for intentional racial discrimination under Title VII can also file under 42 U.S.C. 1981 at the same time. 42 U.S.C. 1981 prohibits discrimination in the making or enforcement of contracts against or in favor of any race. The relationship between an employer and its employee is considered contractual. So let's establish that first. To make and enforce contracts includes making, performance, modification, and termination of contracts, and the enjoyment of all benefits, privileges, terms, and conditions of the contractual relationship. And any violation by the employer gives the individual a right to sue under that statute. I trust this information has been helpful to you. And until next time, I am Advocate Lucinda, your empowerment lawyer.